What's up, everybody? I'm back with part 3 of Kathleen Zellner's filing on behalf of Stephen Avery a petition for review to the Supreme Court of the state of Wisconsin. Going to jump right back into it, right where we left off. We are now on page 16. Stephen Avery has not waived his Brady and interest of justice claims set forth in his petition. In Stephen Avery's third motion, Stephen Avery raised Brady claims relating to the information from the new witnesses and also raised an interest of justice argument. As for his first Brady claim concerning the suppression of the Thomas Sawinski evidence, Stephen Avery attached affidavits and documents showing that after Thomas Sawinski contacted Stephen Avery's current post-conviction counsel, initially obtained FOIA produced audio recordings which did not contain the Thomas Sawinski call, nor did they contain any dates or times of the calls produced. Then, in May of 2022, Stephen Avery's current post-conviction counsel received a partial recording of the suppressed Thomas Sawinski call to the Manitowoc Sheriff's Office on November the 6th. Thomas Sawinski's ex-girlfriend, Devin Novak, recognized and identified Thomas Sawinski's voice on the recording of Thomas Sawinski's phone call made to the Sheriff's Office on November the 6th, 2005 at 10:28 p.m. Stephen Avery, it feels like I've read this stuff earlier in the filing, or it sounds like I did. It's because I did. These things repeat themselves like crazy. Stephen Avery's investigator interviewed Thomas Sawinski again and played the same audio recording of the phone call, and Thomas Sawinski identified his voice in the audio recording of the phone call. The record of Thomas Sawinski's call was never disclosed by the state to Stephen Avery's trial defense counsel prior to or during the trial. If the call had been disclosed, Stephen Avery's trial defense counsel would have traced the call to Thomas Sawinski by subpoenaing the phone numbers. Stephen Avery if all of this stuff came up in the original trial, it would have made a giant difference. I'm not saying they would have found Stephen Avery innocent, but it would have made a giant difference in the outcome of things, I believe. Stephen Avery's sufficiently pled his Brady claim concerning the Thomas Sawinski evidence in his motion for post-conviction relief, and this was not the issue disputed by the Circuit Court in denying his claim. The Circuit Court did not make any finding that Stephen Avery did not sufficiently plead his Brady claim. Rather, it disputed Stephen Avery's argument regarding the materiality of the evidence. This is very well written and definitely pokes a bunch of holes in a lot of things the state has been talking about and things that went on in the trial. In regard to the Brady claim stemming from the evidence provided by Kevin Ramlow, he described in his affidavit, I have no idea if I pronounced that gentleman's last name correctly, I apologize if it's wrong, that he reported the observation of seeing the RAV4 to a Manitowoc Sheriff's deputy he encountered on November the 4th, 2005. How can they, discredit all of these people having seen the RAV4 other places, Thomas Sawinski's evidence? How can you discredit all of them? Did all of them just pop out of the blue for no reason, for money, for fame? It's strange to me that they don't have to take what these people are saying at face value. To a Manitowoc Sheriff's deputy he encountered on November 4th, 2005 at a Senex station on SDH 147 in Mishicot. I don't know if I say that right either. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy about the conversation between Kevin Ramlow and this deputy about Ramlow's observation of Teresa Hallbach's vehicle. Again, Stephen Avery sufficiently pled his argument in his motion for post-conviction relief. The Circuit Court did not find otherwise, but rather it disputed the materiality of the evidence. The appellate court completely overlooked Kevin Ramlow's evidence. Stephen Avery properly pled his interest of justice claim in his motion. However, applying the same rationale for denying his Brady claims, the Circuit Court found that the defendant asked the court grant him a new trial in the interest of justice pursuant to Wisconsin Statute 805 5.15, giving the above conclusion reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request. The Court of Appeals ignored Stephen Avery's actual pleading and Circuit Court's rationale for denying Stephen Avery an evidentiary hearing and improperly found that Stephen Avery's Brady claim and interest of justice claims were waived on appeal because it claimed that Stephen Avery did not argue that the Brady and interest of justice claims were sufficiently pled. However, this ignores the fact that the Circuit Court's newly found This ignores the fact that the Circuit Court never found that Stephen Avery's claims were insufficiently pled. Rather, the Circuit Court accepted that they were properly pled, but concluded that Stephen Avery's evidence that was suppressed was not material, and for the same reason denied his interest of justice claim. Following the Circuit Court's rationale for denying his claim, Stephen Avery properly raised the issue as to the Circuit Court's misapplication of Brady to his newly discovered evidence on appeal. Stephen Avery argued on appeal that the Circuit Court misapplied the law and required Stephen Avery to also prove Denny in order to satisfy the materiality prong for satisfying Brady. In Stephen Avery's brief, Mr. Avery pointed out that in evaluating Stephen Avery's Brady claim, the Circuit Court did not dispute the prosecution had suppressed the audio recording of Thomas Lewinsky's call, but rather it disputed the materiality and favorability of the evidence. Stephen Avery argued that the Circuit Court's manner in determining Stephen Avery's evidence was not material, was improper. Stephen Avery could not have waived his Brady claims because they are within his argument that the Circuit Court improperly imposed a burden for him to also satisfy the Denny requirements in order to show that his evidence is material for bringing his constitutional claims, which obviously encompasses his multiple Brady violation claims. Because Stephen Avery has not waived his Brady claims and argued on appeal that the Circuit Court improperly held him to an improper standard for evaluating materiality, and the Court of Appeals improperly dismissed his claims as being waived, this court's review is required to adequately resolve the issue. Additionally, because the Court of Appeals affirmed the Circuit Court's misapplication of the law evaluating Mr. Stephen Avery's newly discovered evidence and Brady claims, this court's review is required. Whether the Court of Appeals erred when it did not correctly apply State versus Denny to Stephen Avery's potential third-party suspect evidence. Standard of review: the appellate court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that the appellate court reviews. Stephen Avery provided sufficient facts to meet the Denny requirements in his third motion. In Wisconsin, Denny governs the admissibility of potential third-party perpetrator evidence. Denny requires a showing that there must be a legitimate tendency that the third person could have committed the crime. Legitimate tendency is demonstrated whether the defendant can establish, number 1, motive, 2, opportunity to commit the charged crime, and 3, provide some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances. In deciding Stephen Avery's previous appeal of his second motion for post-conviction relief, the Court of Appeals specifically instructed Stephen Avery about the following, and it has a clip from the other filing there, seemingly have forgotten that it previously found the VLCD evidence might become relevant to showing Dassey's motive if Stephen Avery's third motion showed the missing direct connection of the Court of Appeals decided to adopt the Circuit Court's convoluted and faulty analysis of what is required to satisfy the Denny tests. Both lower courts improperly evaluated the motive prong to the most important of three prongs and imposed an impossible burden to meet in requiring each element, motive, opportunity, and direct connection to be conclusively satisfied. Stephen Avery pled sufficient facts to establish that Bobby had a motive for the murder. And that's where I'm going to end part 3. I'll be back with part 4. I think it's part 4. What do you think of everything going on so far? I'll link everything in the description below so you can get caught up if you're just seeing this one. But let me know. Let me know of everything you think so far of this new filing.